Our final concept in this unit derives from Article 6 of the Constitution. Article 6 contains 3 miscellaneous provisions, including the Supremacy Clause, which states as follows. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. While our discussion of the Dormant Commerce Clause inquired about the effect of federal inaction on the ability of states to regulate, the Supremacy Clause concerns the effect of congressional action on the ability of states to regulate. We addressed this question under the heading of preemption. The case law has recognized 3 kinds of preemption: express preemption, field preemption, and conflict preemption. Under express preemption, congressional intent to preempt is stated in the statute. The only issue is whether the challenged state law falls within the preempted area. A good example of express preemption is the Copyright Act, 17 U.S.C. Section 301A, which states that all legal or equitable rights that are equivalent to any of the exclusive rights within the general scope of copyright and come within the subject matter of copyright are governed exclusively by this title. Thereafter, no person is entitled to any such right or equivalent right in any such work under the common law or statute of any state. This means states cannot enact their own copyright laws. State copyright laws are expressly preempted by federal copyright law. Under field preemption, there must be a clear showing that Congress meant to occupy the field and displace states from regulating the subject matter. Rice v. Santa Fe Elevator Corp., a 1947 case, laid out 2 circumstances under which field preemption may occur. 1, a scheme of federal regulation may be so pervasive as to make reasonable the inference that Congress left no room for the states to supplement it. Or 2, an act of Congress may touch a field in which the federal interest is so dominant that the federal system will be assumed to preclude state laws on the same subject. Conflict preemption is even fuzzier than field preemption. As the court noted in Hines v. Davidovitz, there is no one crystal clear, distinctly marked formula for conflict preemption. The court will ask whether, under the circumstances of the case, the state law stands as an obstacle to the accomplishment and execution of the purposes of Congress. In Florida Lime and Avocado Growers Inc. v. Paul, the court noted 2 circumstances under which this might occur. 1, if there's a physical impossibility of complying with both federal and state standards, and 2, if federal standards are meant to be uniform or minimum standards. Obviously, these rules are hard to apply in the abstract. Read the Pacific Gas and Electric Co. case and notes in the casebook, and we'll work through some specific additional examples when we meet together in class. This is the end of the lectures for this unit.